listeners. My name is Dr. Sayyid Ali Nawaz Zaidi. I am working as an Associate Professor, Department of Law, Aligarh Muslim University, Aligarh. Today we will discuss about environment. My topic of lecture is awareness about environmental protection acts for the teachers, educators. With the development of science and technology and with the ever increasing world population, came tremendous changes in the human environment. These changes upset the eco-laws of nature, thereby are shaking the balance of human life. It is therefore become necessary to regulate human behavior and social transactions with new laws designed to suit the changing conditions and value. In order to manage the facts and face the myriad challenges of the ever-changing environment, a new branch of law known as environmental law emerged. The Environmental Protection Acts defines the term environment as one which includes water, air and land and the interrelationship which exists between water, air and land and human beings, other living creatures, plants, microorganisms and property. The principal source of environmental laws are namely common law developed by courts through judicial decisions and statutes comprising acts, rules, regulations, notification and other forms of delegated legislations. It is said that environmental law is an amalgam of common law and statutory practice. Now we will take up the constitutional provisions regarding environment. Article 48A and Article 51A, Clause G. Initially, the Constitution of India had no direct provisions for environmental protection. Global consciousness for the protection of environment in the 70s, Stockholm Conference and increasing awareness of environmental crisis prompted the Indian government to enact 42nd Amendment to the Constitution in 1976. The Constitution was in amendment to introduce direct provisions for protection of environment. This 42nd Amendment and Article 48 to the Directive Principle of State Policy, Article 48A, the article states, the state shall endeavor to protect and improve the environment and to safeguard the forest and the wildlife of the country. The said amendment imposes a responsibility on every citizen in the form of fundamental duty. Article 51A, Clause G deals with the fundamental duties of the citizen states. It shall be the duty of every citizen of India to protect and to improve the natural environment including forest, lake, rivers, wildlife and to have compassion for living creature. Thus, protection and environment of natural environment is the duty of state under Article 48A and every citizen under Article 51A, subclause G deals with relevant provisions. Article 253 states that Parliament has power to make any law for the whole or any part of the country for implementing any treaty, agreement or convention with any other country. In simple words, this article suggests that in the wake of Stockholm Conference in 1972, Parliament has the power to legislate on all matters linked to the preservation of natural environment. Parliament use of Article 253 to enact Air Act and Environmental Act confirms this view. These acts were created to implement the decisions reached to Stockholm Conference. Environmental Protections Act. The constitutional provisions are backed by the number of legislations, act and rules. Most of our environmental legislations are act of the Parliament or the state legislatures. These acts generally delegate power to regulate agencies to make rules for the purpose of their implementation. Number 1, the Water Prevention and Control of Pollution Act 1974 and Amendment 1988. The main objective of this act is to provide prevention and control of water pollution and maintaining or restoring the wholesomeness and purity of water in the streams of wells or on land also. The Act vests regulatory authorities in State Pollution Control Board and empowers these boards to establish and enforce effluents standards of factories discharging pollutants into water bodies. A Central Pollution Control Board performs the same function for union territories and formulates policy and coordinates activities of different boards. The State Pollution Control Boards control sewage and industrial effluents discharged by approving, rejecting and impose conditions while granting consent to discharge. Number 2, the Air Prevention and Control of Pollution Act 1981. The main objective of this act are to improve the quality of air and to prevent, control and abate air pollution in the country. Under the Air Act, all industries operating within designated air pollution control areas must obtain a consent permit from the state boards. The states are required to prescribe emission standards for industry and automobiles after consulting the central board and noting its ambient and quality standards. Number 3, the Environmental Protection Act of 1986, which is very important. In the wake of the Bhopal tragedy, the Government of India enacted the Environmental Protection Act of 1986. In this act, main emphasis is given to the environment, defined to include water, air and land, and the interrelationship which exists among water, air and lands, and human beings and other living creatures, plants, microorganisms and property. The Environmental Protection Act 1986 contains significant innovations for its enforcement, not containing any other pollution control legislations at the time of Act's adoption. Section 19 provides that any person, in addition to the authorized government officials, may file a complaint with the court alleging an offence under the Act. The citizens suit provisions requires that the person has to give notice of not less than 60 days of the alleged offence of pollution to the central government or the competent authority. Under the Act, the central government may, by notification in the Office Gazette, make rules for the enforcement of the Act. Number 4, the Wildlife Protection Act of 1972 and Amendment 1982. Wildlife Act provides for the State Wildlife Advisory Board regulations for hunting wild animals and birds, establishment of sanctuaries and national parks, regulations for trade in wild animals, animal products and trophies, and judicial imposed penalties for violating the Act. An amendment of the Act in 1982 introduced a provision permitting the capture and transportation of wild animals for the scientific management of animal population. Number 5, Forest Conservation Act of 1980. First Forest Act was enacted in 1927. This is one of the many surviving colonial legislations. It was enacted to consolidate the law related to forests, the transit of forest produce, and the duty leviable on timber and other forest produce. Subsequently, the Forest Conservation Act was promulgated in 1980 to make certain reforms over preceding Act of 1927. In 1927 Act deals with the 4 categories of forest, namely reserve forest, village forest, protected forest and private forest. A state may declare forest lands or wastelands as reserve forest and may sell the produce from this forest. The preservation of protected forests is enforced through rules, license and criminal prosecutions. Forest officers and their staff administer the Forest Act. Number 6, which is quite new act, Biodiversity Act 2000. The main intent of this legislation is to protect India rich biodiversity and associated knowledge against their use by foreign individuals and organizations without sharing the benefits arising out of such use, and to check biopiracy. The Act provides for setting up of a National Biodiversity Authority (NBA), the State Biodiversity Board (SSBs) and Biodiversity Management Committees (BMCs) in local bodies. NBA and SSB are required to consult BMC and its decision relating to use of biological resources or related knowledge within their jurisdiction and BMC are to promote conservation, sustainable use and documentation of biodiversity. All foreign nationals or organizations require prior approval of NBA for obtaining biological resources and associated knowledge for any use. Indian entities require approval of NBA for transferring result of research with respect to any biological resources to foreign nationals organizations. Collaborative research project and exchange of knowledge and resources under these projects are exempted, provided they are drawn as per the policy guidelines of the central government and have its approval. The objective of conservation, sustainable use and benefit sharing, which is very important. However, Indian citizens, entities, local people, including Vads and Hakims, to have free access to use biological resources within the country of their own use, medicinal as research purposes. So, flora and fauna conservation attempt, which is very important attempts, and we have to deal with this. The Environment Protection Act 1986, the Environment Protection Act 1986 was constituted on 19th November 1986 to provide for the protection and improvement of environment and for matters connected with environment, that lays down the standards, policies, act of environmental degradation and policies for improvement of national and invention of human beings from environmental hazards. It describes rules to regulate environmental pollution, laying down procedures and standard for industrial waste, emission, hazardous waste, etc. Besides, it deals with the prevention, control and abatement of environmental pollution. The last few decades have been emergence of human encroachment to an extent that has never been seen before. This is one of the greatest threats to the Indian wildlife. In order to overcome the result of human encroachment, and many industrial parks as well as protected areas has been established so far, and the first come in 1935, also in 1972. To protect the tiger and wildlife in India, the Wildlife Protection Act and Project Tiger to safeguard were enacted. The following are the major conservation projects ongoing in India. Number 1, Project Hangul 1970, Project Lion 1972, Project Tiger 1973, Project Crocodile 1974, Project Brown Antelope Deer 1981, Project Elephant 1991-92, Project Ganga Dolphin 1997, Project Snow Leopard 2009. Biological Diversity Act 2002. The government passed the Biodiversity Act to conserve and promote sustainable use of biological diversity and to regulate and the access to biological resources of the country with equitable share in benefits. It set up National Biodiversity Authority (NBA), State Biodiversity Board (SBB), and diversity management committees. Besides, it aimed to respect and protect knowledge of local communities, traditional knowledge related to biodiversity, and secured sharing of benefits with local people and conservation of biological resources and holders of knowledge and information relating to the use of biological resources. Besides, it is also has been provisions for notifying heritage sites by state government in consultation with local bodies. Now, we have to take up other issues like national and international agencies and their work. National bodies, number one, Ministry of Environment and Forest, which is the supreme body. Ministry of Environment and Forest is the nodal agency in the administrative structure of central government for the planning, promotion, coordination and overseeing the implementation of environmental and forest programs. The ministry is also the nodal agency in the country for the United Nations Environment Program UNEP. The principal activities undertaken by Ministry of Environment and Forest consist of conservation and survey of flora, fauna, forest and wildlife. Number 2, prevention and control of pollution. Number 3, afforestation and regeneration of degraded areas. Number 4, protection of environment in the framework of legislations. Number 5, welfare of animals. The main tool utilized for this include environmental survey, impact assessment, control of pollution, regeneration programs, support to organizations, research to solve solutions, and training to augment the requisite manpower, collection of dissemination of environmental information, and creation of environmental awareness among all sectors of the country's population. Number 2, Central Pollution Control Board. The Central Pollution Control Board CPCB is a statutory organization, was constituted in September 1974. Under the Water Prevention and Control of Pollution Act 1974, CPCB was entrusted with the powers and functions under the Air Prevention Control of Pollution Act 1981. It serves as a field formation and also provides technical services to the Ministry of Environment and Forest of the provisions of the Environment Protection Act 1986. Principal functions of the CPCB as spelled out in the Water Prevention and Control Pollution Act 1974 and the Air Prevention and Control Pollution Act 1981 to promote the cleanness of streams and wells in different areas of states by prevention, control and abatement of water pollution, and improve the quality of air and to prevent, control or abate air pollution in the country. In India, states do not pursue independent environmental policy of their own, but adopt the policies formulated at the national level subject to such variations as may be necessary to suit the local conditions. The central government has also been issuing guidelines to the state on various environmental matters. Number 3, the Indian Board for Wildlife IBWL. National Board for Wildlife is a statutory organization constituted under the Wildlife Protection Act 1972. The primary function of the board is to promote the conservation and development of wildlife and forests. It has power to review all wildlife related matters and approve projects in the around national parks and sanctuaries. No alteration of boundaries in the national parks and wildlife sanctuaries can be done without approval of NBWL. Number 4, National Green Tribunal. The National Green Tribunal has been established for effective and expeditious disposal of cases relating to environmental protection and conservation of forests and other natural resources, including enforcement of any legal right relating to environment and giving relief and compensation for damages to the person and the property and for matters connected there with or incidental thereto. It is a specialized body equipped with the necessary expertise to handle environmental disputes involving multidisciplinary issue. The tribunal shall not be bound by the procedure laid down under the Code of Civil Procedure 1908, which is known as CPC, but shall be guided by principle of natural justice. The tribunal, dedicated jurisdiction in environmental matters, shall provide speedy environmental justice and help reduce the burden of litigation in the higher courts. The tribunal is mandate to make an endeavor of disposal of application or appeals finally within 6 months of filing of the same. Fifth, the National Tiger Conservation Authority. The National Tiger Conservation Authority is a statutory body under the Ministry of Environment, Forest and Climate Change, constituted under enabling provisions of Wildlife Protection Act 1972, as amended in 2006, for strengthening tiger conservation as per powers and function assigned to it under the said Act. Sixth, Wildlife Crime Control Bureau. The Government of India constituted a statutory body, the Wildlife Crime Control Bureau, in 2007 by amending the Wildlife Protection Act 1972, a special act to protect the wildlife in the country. The Bureau will complement the efforts of state governments, primary enforcers of the Wildlife Protection Act 1972 and other enforcement agency of the country. Genetic Engineering Approval Committee. It functions under the Ministry of Environment and Forest. It is the apex body to accord environmental approval of activities involving large-scale use of hazardous microorganisms and recombinants in research and industrial production. It is also mandated with approving the release of genetically engineered organisms and products into the environment, including experimental field trials. Now, the Central Zoo Authority. The Central Zoo Authority of India, CZA, which is very prevalent, is the body of the Government of India responsible for oversight of zoos. It is affiliated members of the World Association of Zoos and Aquariums. The Central Zoo Authority has been constituted under the Wildlife Protection Act. The main objective of the authority is to complement the national effort to conservation of wildlife. Every zoo in the country is required to obtain recognition from the authority for its operation. The National Afforestation and Eco-Development Board, NAEB, is responsible for promoting afforestation, tree planting, ecological restoration and eco-development activities in the country, with special attention to the degraded forest areas and lands adjoining the forest areas, national parks, sanctuaries and other protected areas, as well as the ecologically fragile areas like Western Himalayas, Aravallis, Western Ghats, etc. It involves mechanism of ecological restoration of degraded forest areas and joining lands through systematic planning and implementation in a cost-effective manner. It restores fuel wood, fodder, timber and other forest produce on the degraded forest and adjoining lands in order to meet the demand for these items. It sponsors research and extension of research finding of disseminate new and proper technologies for the regeneration and development of degraded forest areas and adjoining lands. Wildlife Institution of India. WII, which is very important, is an autonomous institution under the Ministry of Environment, Forest and Climate Change, Government of India. WII carries out wildlife research in areas of study like biodiversity, endangered species, wildlife policy, wildlife management, wildlife forensics, spatial modelings, eco-development, habitat ecology and climate change. WII has a research facility which includes forensics, remote sensing and GIS, laboratory, herbarium and an electronic library. Compensatory Afforestation Fund Management Planning Authority, which is known as CAMPA, has been created by the Ministry of Environment and Forest. It creates Compensatory Afforestation Fund CAF by the Ministry of Environment and Forest. The CAMPA bill has established a permanent national compensatory afforestation fund and the public account of India. It also allows the state to establish state compensatory afforestation funds. The national fund will be under the central government and managed by a national compensatory afforestation fund management and planning authority, CAMPA. The central government will appoint a state CAMPA in each state. The state CAMPA will be responsible for the management of state funds. This is another important body, Zoological Survey of India, ZSI, was established to promote the survey, exploration and research of the fauna and in the region. The activities like ZSI are coordinated by the Conservation and Survey Division under the Ministry of Environment, Forest and Climate Change, Government of India. Primary objectives are exploring, surveying, inventorying and monitoring of faunal diversity in various states, selected ecosystems and protected areas of India, taxonomy, studies of the faunal components, collected status survey of threatened and economic species, preparation of red data book, fauna of India and fauna of states. The Botanical Survey of India, BSI, is the apex research organization under the MOEF for carrying out taxonomic and floristic studies on wild plant resources of the country. The prime objective of the Botanical Survey of India, BSI, is to undertake intensive floristic survey and collect accurate and detailed information on the occurrence, distribution, ecological and economic utility of plant in the country. Next is Forest Survey of India. Forest Survey of India, FCI, is engaged in the assessment of the country's forest resources on regular intervals. It is involved in forest cover assessment of the country on biennial basis by interpretation of satellite data on a 2-year cycle and present the information in the form of India's State of Forest Report. It also form inventory forest and tree outside forest TOF in both urban and rural areas. In conclusion, human beings can ensure fundamental equality and adequate conditions of life in an environment that permits a life of dignity and well-being. There is an urgent need to formulate law keeping in mind the fact that those who pollute or destroy the natural environment are not just committing a crime against nature, but are violating human rights as well. Indeed, health seems to be the subject that bridges gaps between two fields of environmental protection and human rights. The advancement of relationship between human rights and the environment would enable incorporation of human rights principles within an environmental scope, such as anti-discrimination standards, the need for social participation in the conservational efforts of flora and fauna. National and international agencies should coordinate and provide an enabling environment for protection efforts and join people and civil society in awareness and conservation efforts. Thank you.